Welcome to literary and jury charge practice. We'll start out with some jury charge. Ready? Here we go. There was no question but that his rights were read. Particularly, the question that was raised was whether the defendant had wiretaps on his phone. Wiretaps are not legal in the state. After his rights were read, the suspect is allowed to have an attorney represent him in court. The police are trained to inform the suspect that he has certain rights that are granted to him or her according to the Constitution of the United States. These constitutional rights are important to the individual as he proceeds to trial. The Constitution provides that there are a number of rights that the person has before, during, and after the trial. A person is not to be arrested without cause. There must be a reason for the arrest. The cause is referred to as probable cause. Probable cause means that the person probably committed the crime. There is enough evidence to say that he probably did it. After the person is arrested, the person has the right to remain silent and to be represented by an attorney. At trial, the person is to have the right to be heard in front of a jury of his peers. After the trial, he has a right to receive a just punishment. A just punishment, where murder is concerned, may involve the death penalty. In this case, the defendant would have been subjected to the death penalty had he been found guilty. The right to a speedy and public trial and jury is an important right. In some places, that right is not granted. Another right is the right to confront witnesses. The person has the right to hear the witness in court and to respond. The first time that he is allowed to appear is called the initial appearance. Before a person is questioned, the person is supposed to be informed of his rights. An important case decision is the Miranda decision that sets forth the principles that a person must be informed of his rights. The rights that a person is to be informed of is his right to an attorney and his right to remain silent. The officer or officers who are taking the person in for questioning must inform the suspect that he has the right to an attorney and the right to remain silent. These rights have been set forth for him in the Constitution. However, it is the Miranda decision that requires that the person be informed of these rights. There was no question, but the police read the Miranda rights to the defendant. The question was whether there was a wiretap placed on the phone of the defendant. The Miranda warning tells you that you have the right to remain silent and the right to an attorney. These two rights are so important that a Supreme Court ruling determined that police must tell the arrested party of their constitutional rights. A judge can also require that a gag order be issued to keep information about the trial from getting released. A defendant must post bail to be released from jail and will lose that money if he or she fails to appear in court. A bondsman will, for a certain percent of the bail, act as the surety and post the money. In states where there is no bondsman, the court acts as the bondsman. This means that the defendant must pay the court the bail. If you are released on your own recognizance, you need not pay anything. The judge would not release the individual on his own recognizance, nor would he allow the defendant to post bail. He was not convinced that the defendant would be available for his court appearances. The judge should issue a bench warrant if he failed to appear in court. Now for some more jury charge practice. Ready? Here we go. The test is not the number of witnesses, but the convincing force of the evidence. Keep in mind that the number of witnesses is not the deciding issue. The deciding issue is the evidence. You must examine the evidence and decide whether the individual is guilty or innocent. In making your decision, it is important that you know the difference between direct and circumstantial types of evidence. Evidence may be classed as either of the two types. The two are important for you to understand in making your decision. The evidence that has been presented is in the form of testimony from several witnesses who saw the accident on one side and several tests done by the other side. The fact that the defendant went to another state and had to be extradited does not mean that he was guilty. You must not let this information cause you to find the defendant guilty. You must not let any information other than what has been presented in court affect your decision. Direct evidence proves a fact without an inference. You must determine if there was proof that did not require an inference. Proof that does not require an inference provides direct evidence. An inference is a deduction. The only inference that you should make from the evidence is that which can be believed. The law is clear when it speaks to the question of inference. Direct evidence provides a fact without an inference. If you find that the direct testimony is such that it is credible, you must find in favor of the defendant and move to clear him. If you decide that he is innocent, that is what you must do. In direct evidence, there is no deduction. The fact is what it is. As the district attorney pointed out, when you see someone commit the crime, that is direct evidence. There are some people who testified that they saw the accident occur and that there was no way that the defendant caused the accident. There were others who testified that the accident was a direct cause of the defendant. Now you must decide. Seeing the accident happen is direct evidence because it does not require an inference. You do not have to apply any inference. You do not have to arrive at the conclusion from any other means. You do not have to use the test to determine your decision. You must decide whether the testimony of the witness is credible. In circumstantial evidence, there is the presence of an inference. Circumstantial evidence proves a fact from which an inference can be drawn. You see the results of a crime and you see someone leaving the scene in a hurry. That is the case. Several people saw the accident occurring and were able to give testimony as to what happened. In this matter, the evidence is direct. Some testified that they saw the defendant leaving the scene. The district attorney used this to indicate that there was guilt on the part of the defendant. The defendant's attorney indicated that the defendant left the scene to get help because no one was there to help. If someone did not directly see the crime occurring, the evidence would be circumstantial. The evidence would be circumstantial because you did not actually see the crime occurring. The tests are not direct evidence. The tests used to determine the speed at which the defendant was driving are circumstantial evidence. The case is not just an accident case, it is a criminal case because there is the determination that a crime had been committed. Both sides in this case provided direct evidence and circumstantial evidence. You must determine whether there is enough evidence to prove the case set forth by the district attorney. If there is not, you must find the defendant innocent and clear him. You need to know for the purposes of this trial how the law views direct and circumstantial evidence. The law makes no distinction between the two as to the degree of proof required. The circumstantial evidence provided by the district attorney were the tests done to determine the speed at which the defendant was moving when the accident occurred. You were told that by the district attorney. You have to determine whether, for the purpose of this trial, the evidence that the district attorney presented was sufficient to prove the case beyond a reasonable doubt. It is important that the district attorney prove his case beyond a reasonable doubt and that no evidence has been suppressed. Now let's try this jury charge. The subject is negligence. Ready? Members of the jury, the defendant at the time of the installation knew of the explosive character of the gas to be used in the operation of this gas stove. So the question here presented is whether or not he exercised ordinary care and prudence in making the installation, which he did make. The test of negligence in this case is the same as in other negligence cases, that is, the probability or foreseeability of injury to someone. If the defendant might have foreseen that under the circumstances some injury to someone was likely to result from his act or omission, he is liable for any injury proximately resulting. The gas to be used in this stove was a dangerous agency of which the defendant had knowledge, and a higher degree of care is required in dealing with a dangerous agency than in the ordinary affairs of life or business, which involve little or no risk. such higher degree of care in such cases, ordinary care under the circumstances. If a person fails to exercise the degree of care required of him in dealing with dangerous instrumentalities or agencies and negligently permits danger to exist which results in injury to another without negligence on the part of the person so injured, he is answerable for the injury so sustained. The degree of care varies with the danger involved, and where the danger is great, a higher degree of care must be exercised. From anything the court has said or done in this case, you are not to understand that he has any opinion as to the facts appearing in evidence. It is the duty and province of the jury to weigh the evidence which has been introduced in the case and to determine what facts or facts evidence establishes, and having done so, to apply such facts, the law, as stated in these instructions. All right, now let's try some literary practice. And this is called God Bless Our Happy Home. Ready? Here we go. Divorce court, sometimes called domestic court or family court, has probably seen the most changes during the last quarter of the 20th century. In the late 1970s, the idea that there might be some other partner waiting in the wings for the divorce to become final was very hush-hush. In custody matters, it was taboo to cohabitate with someone other than the spouse, and if a father or mother wanted to see their children for visitation, it would be necessary for the third party to be scarce for the visitation period of time. By the late 1980s and early 1990s, it was acceptable to have a third party around or even cohabitate as long as the children were not subjected to inappropriate actions. Domestic court definitely reflected the changing morals of the country. By the mid to late 90s rolled around. One of our first cases on our last rotation through this bastion of raw emotions involved temporary orders, those to be in place during the pendency of the action, and whether it was appropriate for a 6-year-old to visit his father who had left his mother to move in with another man, and for the boy to stay overnight in a 1-bedroom apartment with the 2 men. The father saw absolutely nothing wrong with the arrangement and wanted to indoctrinate the boy into his new lifestyle. There are fringe players involved in family court. These include child custody investigators, social workers, therapists, psychologists, and psychiatrists. Each time I spent a rotation in domestic, I would marvel at what the psychobabble of the day was. Our last involved mostly people who were thought to be bipolar. One of our early cases in domestic court in Denver involved a couple who had married after their spouses of the first 3/4 of their lives had passed on. The wife was 78 and the husband was 79 when the dissolution hearing took place. They had been married about 5 years earlier. It was important to the husband that he was seen as being cooperative by the court. Question: Are you married to the petitioner? Answer: Yeah, we had a pretty wild life, but she wants to get divorced, so that's fine with me. Whatever she wants. We had a wild time, though. Question: Do you understand you have a right to request maintenance in this case? Answer: Yeah, I'll be glad to mow the lawn and take care of the place. Anything you want me to do in the house, I'd be glad to do it. Question: And the maintenance I'm referring to is what we used to call alimony. Answer: Yeah. Question: And that's what I'm asking about, is alimony? Answer: Yeah, anything she wants is fine. I'll mow it every week. Do whatever she needs. Question: All right, but as far as alimony or maintenance, you understand that you can't come back at a later date and ask for it? Answer: Yeah, we want to be good friends. She's a wonderful, wonderful woman. We belong to the same church. Ms. Walsh, Great, I have no further questions, Your Honor. The court, all right, you may step down. When the husband stepped down from the witness stand, he walked over to his soon-to-be ex-wife and shook and kissed her hand. It really was a lovely gesture. Little problems and their resolution can take on a whole new importance in divorce court. For instance, when we moved to courtroom 21, the previous staff took their water pitchers for counsel tables and the witness stand. Not thinking much of it, we simply ordered a new set. The water pitchers that were delivered had very strange lids that simply popped open when a certain angle was reached. Gravity, maybe? In any event, we were in a hearing right after the pitchers were delivered. The bailiff filled them with water and promptly put them in their places. None of us had tried the pitchers ourselves, so we had no idea that if anyone tipped the pitcher just a millimeter too far, the entire contents of the vessel would rush out. Of course, it wasn't something that should be humorous to see a slick divorce attorney who was callously cross-examining the other party in the case with no mercy pick up a cup and the pitcher and start to pour himself some water at a tense moment only to be totally drenched a moment later. It shouldn't be humorous, but it was. We really were mortified and promptly put a note on the top of the lids urging caution. While this seemed to help some people, others seemed to read the note, which absolutely couldn't be missed, and promptly did that which was warned against. Our next step was to take the lids off in the hope that people would be more careful. That solution was quickly nixed when a large fly landed in the pitcher by the water witness stand in the middle of testimony. Finally, the pitchers were emptied and put on the top of a cabinet in the rear of the courtroom. We had ordered a set of a different kind of pitcher, but what had taken only a day or two to receive the week before now took 2 weeks. To our horror, we entered the courtroom after taking the docket call to begin the first hearing, and the water pitchers had mysteriously reappeared on the counsel tables. We launched right into the case, so nothing was said at that point, but it wasn't long before water was dripping off petitioner's counsel table, and petitioner's attorney was running around the table trying to keep the exhibits dry. Well, as the next recess, we moved the pitchers into the conference room and placed them on the top shelf of the court rack. No one should be able to get them from there. It was hit and miss water-wise for the next days until the new set of pitchers arrived. These, however, had lids on them that did not flip open. They unscrewed somehow, and nobody could open them unless that was the only thing they were doing at the time, because of the concentration level necessary to open the lid and pour the water. Even at that, there seemed to be an inordinate amount of water soaking our carpet. Right, let's get back to our literary. Ready? Here we go. Needless to say, the judge was becoming very irritated by something that shouldn't have been difficult to resolve. As our staff discussed the matter of saving our jobs and a plausible solution to the problem, we set about visiting other courtrooms in the building to see what water pitchers were being used. Glory be, we found a set of the old standbys in our previous quarters in the jury room, obviously neglected and to be relegated to the water pitcher pitch pile. We grabbed them and safely installed them as fixtures in our courtroom. What a relief. Problem solved, even though the outdated water pitchers weren't quite as pretty. To tell you the truth, we missed the comic diversion the other pitchers had caused, but then again, the judge was much happier. Paying support in domestic cases, whether it be maintenance or child support, always seems to be a sticking point. In Wichita, we had what we called Father's Day every Friday afternoon. The docket was composed entirely of cases involving delinquent child support or other contempt matters. The judge always chose a particularly bad case to call up first, one where jail time was a distinct possibility. Once a case of the nature was completed with the respondent on the way to jail, it was amazing how many of the others waiting would approach the district attorney to settle their cases. One day we had a man in on a contempt for non-payment of child support who had been eating his Wheaties. He was representing himself and kept telling the judge that he simply couldn't pay his support obligation because he had all of his other bills and his truck payment to pay. When the judge took no pity upon him and sentenced him to 60 days, he flew into a rage. Now, all judges have what we call panic buttons close to them on the bench, where they can call silently for sheriffs and other officers to assist if things get out of hand. As this very large man began to scream and throw things around in the courtroom, the judge hit his panic button. The judge was calmly advising the man that he should take a seat in the jury box and the sheriff would be in shortly to escort him to jail. All the while the judge was pushing the button over and over again. I turned to him and asked if I should see what was taking so long. He replied in the affirmative, and I got up from my chair to leave the courtroom. As I did, the sleeve of my blouse caught on the sheet metal basket where the court files were kept for the day's hearings. The sleeve ripped all the way to the wrist. I ran to our chambers to see what the delay was and couldn't find anyone anywhere. When I returned to the courtroom, a lawyer, about half the size of the respondent, had the large man up against the wall in the courtroom saying, "You're not helping yourself, son. This isn't going to help your case. Just calm down and see what happens." About that time, the sheriffs finally arrived and took the man into custody. Now, my fiance was a judicial services officer, deputy sheriff at that time, and the information that reached him was there had been an incident in my courtroom and my blouse had been torn off in the scuffle. Well, you can imagine how that made for an unhappy handling of the respondent when he arrived in the jail. He never did cooperate, but eventually paid the amount of bond, which would catch up his child support, and we didn't see him again, at least on our domestic watch. As for the attorney that saved the day, he was somewhat of a hero for the rest of the afternoon. And that will conclude our literary and jury charge practice.